What is your name? All right, so you're charged with possession of drug paraphernalia. That charge is a simple misdemeanor. Carries a fine of not less than $65 or greater than $625. Also carries up to 30 days in jail. You have two choices for today's purposes. You can plead not guilty. If you plead not guilty, we'll set it out for hearing at a later time. If you plead guilty, I'm going to impose a $200 fine, 35% surcharge, which would be $70, $60 total cost.
And that's it.
That's it.
All right.
You know, I'm not sure what the driver's license ramifications of this are. It's not anything to do with that.
Oh, I don't have a driver's license, so.
Why is that?
I've got some more fines to pay before I can get it.
Sounds like you're doing a real good job in life.
I'm working on it.
Not too hard, it doesn't look like.
Yeah, I suppose so. I can see where you get that from.
Are you working?
I have an application to take in today, and
Leave your days off, and I hear that.
I'm almost 100% positive that I have this job. Since I reside in Hurley, not much for jobs there. With no license, it's hard to get around.
You know, one reason why you don't have a license is because you're stupid.
I'm not going to disagree with you. Sometimes I do make pretty stupid decisions.
What do you want to do here? Yeah, if you need some time to pay it, I can give you some time.
Yeah.
What's your mailing address?
My mailing address would be 407
Highway 71?
Early Highway, yes.
You don't have a post office box. Okay. You let me know what you want to do.
Well, I'd like to plead not guilty since the arresting officer didn't read our rights. Well, my rights, I guess, isn't mine either, but.
I mean, I don't think there's anything good to know. The way that would come into play would be if you had confessed or something, you know, you need to raise your rights. I need to advise you of your rights.
Oh, yeah. I was misunderstood there.
So, you know, and that's basically what I told you. You have a right to plead guilty or not guilty. I'm not intending to impose a jail sentence in this case, so it's simple misdemeanor. You are not entitled to court-appointed counsel.
All right. Well, I'll just go ahead and plead guilty and take the fine. As I said, though, I do have other fines that I have to pay.
It's not my problem.
Understood.
Maybe you should leave drugs alone. Use that money for paying fines. I don't think they give drugs away, but maybe they do.
Yeah, it's not the kind of world we live in. I think we're just giving away for free. Nothing's just put in your hands.
How much time do you need? $330.
I've got over, it's probably about $1,500 in fines. So, and I'm just getting a job as a dishwasher or cook for right now.
There you go.
I'll be working as hard as I can, and then we're going to have a week on this. Go to my fines so I can get.
I'll give you until October 30th, and I'm going to set a show cause hearing for November 3rd. If it's not paid, I'm going to put you in jail for 10 days.
All right.
That's what you need, is a little taste of jail.
I was retained but in jail that night.
You know, but what you need is about 30 days, and that kind of wake you up a little bit. But I'm not gonna give it to you on a paraphernalia charge.
Appreciate it, sir.
Probably aren't gonna want that many if you're on an assault charge or something like that, because you're one of those kind of guys that just needs a little jail time to figure out life a little bit. Third. November 2014. 10:00. Oh, 18. Whoops. I forgot the LEI surcharge, which I have to impose, which is another $5. All drug-related approaches have to. So that's now $455. There you go, send the next person in, please.
All right, thanks, sir.
Up here, Jacob. We're probably looking at jail time on this.
For what?
We have two charges. One is possession of drug paraphernalia. Don't lean on my bench.
Sorry.
On the interference charge
What's that for?
for refusing to cooperate when they were trying to arrest you.
I didn't refuse to cooperate.
You know, save it for quickly not guilty and set it for trial.
Can I make a call to my dad before I decide anything?
Yeah. Got a phone?
Yeah.
Go call him.
Can I step out?
So here's, I mean, we just go through it with you first. You have two charges. One is possession of drug paraphernalia. If you plead guilty to that, I'm going to impose a $200 fine, $70 surcharge, $60 of court costs, $125 law enforcement initiative surcharge is going to cost you $455. On the interference with official acts, if you plead guilty to that, I'm going to give you 10 days in jail.
So on the paraphernalia, I'm gonna have to spend $450.
$455.
And then, if I take the interference, I got, it's 10 days in jail.
Correct.
All right.
Plus $60 court costs. All right.
Is that a day?
Pardon?
Is that like $60 a day?
No,
Oh, no, you said
$60
court
court costs.
Yeah, my bad.
All right.
I'll go make the call.
Fine.
Should I just come back in when I'm
Yeah, if
done?
there's somebody else out there, send them in.
Okay.
Where are we at, Philip?
Well, I can't get a hold of my dad, but one other thing that he told me is to, if possible, take interference to trial, but probably keep guilty on the paraphernalia.
All right.
Because I probably not gonna get anything better on the paraphernalia than what I'm offered. I already know that.
What are you doing with drugs?
I know, it was a stupid mistake.
Well, you know, are you ever gonna grow up?
I'm trying.
You're not trying very damn hard. Are you working now, Jacob?
Yeah, I work at the hardware store. My dad needs me. I'm gonna start working there full time. I really just did. Yeah, I started there
You need to
this
go
week.
for somebody that's not your dad.
If they would hire me.
Find out what it is to have a boss.
You remind me a lot of the guy that was in this before you know, it's like,
You know, the reason they don't hire you is because of the way you act, you know? At some point in time.
Yeah, and I know that, but you gotta admit that in the years my behavioral and stuff have improved. It's the mental illnesses that I still have to get a hold of. I mean, I'm sure you hear this story all the time, but it is what it is.
Well, using drugs is a choice, you know?
Yes, that
It's
is.
not a,
Yes, I know. That was my fault. I completely agree with that. That was 100%.
worry about what's gonna happen with some of the other people down there in that house, you know? We're not probably being
I don't.
given the best example.
yeah, Jeff, that's good technique. That's good stuff.
Doesn't matter what chair.
Defendant appears on charges of possession of drug paraphernalia. Paraphernalia. And interference with official acts. Period. He elects to enter a guilty plea to the paraphernalia charge and a not guilty plea to the interference with official acts charge. Period. The court sentences the defendant to pay a fine of $200, surcharge of $70, LEI surcharge of $125. And $60 court costs on the paraphernalia charge, period. How much time are you gonna need to pay this?
I'm gonna need some time.
Yep. All right, so what I'm gonna do, Jacob, is I'm gonna give you, like I did the last guy, until October 31st to pay that, so show cause hearing until October 3rd. So that gives you more than 60 days to get it paid, so. But that's all the time I'm gonna give you,
You're gonna give me till October?
till the end of October.
Alright, that works for me.
All right. Well, I gotta finish.
Is there any way I can get a payment plan on that?
What do you got in
$50 a month or something, get it done in 3-4 months.
Well, it's $455, so.
Paid in a little more, I guess, I don't know.
I mean, I guess I'd let you pay $100 a month.
Okay.
And
All right.
that's 5 months, then, you know, it's 100, 100, 100, 155.
It's up to you.
Only the defendant requests a payment plan, period. The court authorizes him to pay the amount due in installments of $100 per month, beginning with a first payment on September 15, 2014, and continuing for an additional 3 months, and with a final payment of $55 due on or before.
It's hard for me to see.
January 15, 2015, period.
It's the day before my birthday.
Day before my anniversary, which will be 44 years for me.
Congratulations.
No thanks. It's
Quite a feat.
this day and age. The clerk shall set the interference with official acts charge for trial, period. The court has advised the defendant that in the event that he is found guilty of that charge, that he will likely receive a jail sentence, period. There you go. Leave that door open on the way out.
All right. Thank you for your time.
Defendant in this case, through her attorney Martha Sybil, has filed a motion for 630.3A hearing, and the court did enter an order saying that the parties may appear for this hearing by phone. Ms. Sybil was trying to contact the court. Apparently there was some sort of problem, so the court has now disconnected that call and expects her to call back shortly.
One of the parties for the 10:30 is out here.
Okay, send her in. Is it a he or a she?
You can go in and straight.
Hi.
Hi.
What is your name?
Todd Bachman.
Yes.
I got Martha again.
Hey, Martha. Hello.
Hello, Magistrate Bush.
Yep.
Okay. Hello, James. Hello, can you hear me? Yes, I can hear you, and the magistrate is on the line as well.
And I also have Todd Bachman just came into the court room.
Ah,
Ms. Sybil, you're representing Miriam, is that correct?
yes, Your Honor.
All right. And so go ahead and tell me what this is all about.
Thank you, Your Honor. On behalf of my client, her employer, J.C. Penney, received interrogatories in the garnishment and responded that her annual compensation was $16,079. And then in the directions for garnishment from the sheriff, it had the court order percent of 25% for the goal amount of $800. Going back to Iowa Code Chapter 642.21, subsection 1, subsection A, has employees expected earnings of $12,000 but less than $16,000, not more than $400 may be garnished per calendar year. So what we are asking the court to do is to limit the garnishment.
Why is that applicable if her earnings are $16,079?
She is only $79 over the limit that is in subsection A, and my client has had a recent downturn in finances due to her current husband going to federal prison. So we would ask the court in equity to limit the garnishment to $400.
But I mean, as I understand it, your motion is based on the fact that somehow the sheriff miscalculated and did not follow the statute, whereas it would appear to me that the sheriff did follow the statute. So, I guess it seems to me that maybe the appropriate relief here might be to talk to the counsel for the plaintiff and see if you can work out some type of a payment arrangement. But I don't think that there's a legal if her earnings are $16,001, then the garnishment amount is correct, I think, according to the
Your Honor,
sheriff's
in
calculations.
Iowa Code Chapter 630.3A, there is a provision that the interests of justice require that a greater amount than provided in 642.21 should be exempt from garnishment. And we would ask the court to use that in the interest of justice, reducing the amount from $800 to $400.
All right, what's counsel for the plaintiff have to say about that?
Yeah, Your Honor, in these types of circumstances, we do not expect the defendant going through a hardship. I understand that her personal financial situation is pretty dire, and so I'm not going to give any sort of hard resistance to this, other than the fact that we will abide by whatever the court deems appropriate in this case, especially in light of a 638 motion, which is just asking for additional relief based on personal circumstance. So whatever the court wants.
Martha, it just seems to me that in order to avoid all these, clerk's fees and sheriff's fees, et cetera, why don't we try to, why don't I order a payment plan? And if the payment plan is, $40 a month, which would be $480 a year, and she pays that, then we're going to avoid all those crazy charges that get involved here. I mean, I don't know how she would feel about that. That would make a lot of sense to me. I'm kind of let's do what makes sense here.
Thank you, Your Honor. If that is what the court orders, my client will certainly abide by that. My client is seriously looking into bankruptcy before the end of the calendar year. So whether it's a reduction in the garnishment or whether it's a payment plan, my client will comply.
So from the plaintiff's side of this thing, if I enter an order to that effect, would the plaintiff have any objection?
Yeah, Your Honor. I mean, if you enter an order that puts the defendant on a particular payment plan, that would be fine as well. The order should address any previously garnished funds. So I believe that there are some funds that are already been seized by her employer, probably in the hands of either the sheriff or the clerk at this time.
Martha, you know how much money how much they've taken?
Your Honor, it's at least been $200, and my client believes that another $200 has been garnished. We would not object to those funds being turned over to the plaintiff as a credit against what my client has paid.
All right. I think I'll do that. You know, I'll order that, you know, that garnished funds to this date be first applied to costs, any balance paid to the plaintiff, that the garnishment, you know, will now be withdrawn, and I'll set her up on a $40 a month payment plan. And let's make that payment plan effective October 1.
Thank you, Your Honor.
Does that sound okay to everybody? I guess maybe I should ask Mr. Bachman, who's here.
Yes.
I don't know if he's paying anything, but it's a joint and several debt, so he's going to get stuck with whatever she doesn't pay, I guess. All right, we'll go that route.
Thank you, Your Honor.
You bet. This matter comes before the court on the defendant, Miriam. Petition for relief under Iowa Code Section 630.3A. She appeared by her attorney, Martha Sybil. And the plaintiff appeared defendant Todd Andrew Bachman appeared in person. By counsel. By telephone, comma. Also by telephone, period. After discussion, it was agreed that the court would order all funds currently garnished be paid by the sheriff to the clerk of court. That the garnishment be withdrawn at this time, comma, and that hereafter the defendant, Miriam Gutierrez, shall pay $40 per month to the plaintiff, beginning with a first payment by the first of each month on October 1, account 2014. Period. We have a defendant?
No, Your Honor.
We're going to give him 10 minutes or so to show up.
10?
This is a matter of the state of Iowa versus William Wesley Doolin. It's STA 0020893. The defendant is charged with the excess gross weight violation in violation of Iowa Code Section 321.466. The record should reflect that this matter. Yes. Well, I'll talk to her, but then don't interrupt me again, because I'm in the middle of a hearing. Yes. Yeah, especially when I'm in the middle of a hearing. Yeah. I mean, yeah, I guess you can leave. The committal is not signed. Then they need to, come in daylight hours and do a committal. Correct. All right. The matter was set for hearing on this date at 11 o'clock a.m. It is now about 11:19 a.m. The state is represented by County Attorney Ben Smith. The defendant is not present, nor anyone on his behalf. Mr. Smith, are you ready to proceed?
Yes, Your Honor.
Call the witness.
The state calls DOT Officer Fred Claycamp to the stand.
How's that spelled again?
C-L-A-Y-C-A-M-P.
Pretty phonetic, huh? As far as the testimony you're about to give in this case will be the truth under penalty of perjury.
I do.
Officer Claycamp, how many years have you been with Iowa DOT Motor Vehicle Enforcement?
Approximately 5 years.
Officer Claycamp, you said you've been at the Motor Vehicle Enforcement about 5 years.
That's correct.
And in that capacity, were you on duty on or around, well, on July 1 of 14?
I was.
Around 11:30 a.m.
That's correct.
in Sac County?
Yes.
And if you could explain to the court, the reason why we're here is you issued a citation to a Mr. William Wesley Newland on that date, at that time, for gross weight exceeding registered weight. Can you explain to the court why you issued that citation and start from, I guess, your first contact with the driver?
I was on that particular day in question. I was working the scale at early Highway 71 and 20, and a vehicle passed southbound, truck passed southbound. I did not pull through the scale. At that point, I activated my emergency lights and caught up to the vehicle and made occasion to stop the vehicle. Had it returned to the scale for commercial vehicle inspection.
Okay, and at what point in time did you ask for his identifying information?
I believe I got his driver's license when I initially made the stop, after I had introduced myself and the reason that I had stopped him.
And to the best of your recollection, the name on the driver's license is in the defendant's name as issued in the citation?
That's correct.
Okay, and the picture of the person that handed you the identification and the picture on the card itself matched?
Yep.
Okay. So you get back to the scale, you do, then what do you do?
Proceeded to have the driver weigh the vehicle. He pulled onto the scale platform, and I recorded the weight of the vehicle at that time.
And what kind of vehicle was it, do you recall?
It was a 2001 white dually pickup pulling a boat.
Okay, so you weighed it, and you noted that it exceeded the registered weight by, I have 2,240 pounds.
That's correct.
And the weight limitation was prescribed by the make and model of vehicle?
When the driver was not the registered owner of the vehicle,
Okay.
but the registration weight fees that were paid on the vehicle were inadequate for the weight of the vehicle.
Okay.
Stop.
Okay, and just out of curiosity, when somebody registers a vehicle, they register a trailer, or they register a vehicle, right?
That's correct.
Okay, and they register so that it can pull a certain amount of weight, or they register it in a certain class, or the same thing?
It's based on the application of what they're going to use the vehicle for. If they're going to haul a load, they have to pay so much fees for load hauled.
So the more weight, the higher probably the fee for the application or the permit. And in this case, it's probably just a boat that weighed a lot more than they thought it did, or.
And this was just the weight. The violation was based on the weight of the truck plus the transfer weight of the boat, not the total weight, because there is a exemption for lightweight vehicles. So the violation issued was based on what the truck weighed with the transfer weight from the boat.
What's the transfer weight?
Basically any ton weight that was attached to the power unit.
How do you determine that?
They pull on the scale, and the truck is situated on the scale platform, and the wheels of the boat trailer would be off the scale platform.
And the scale platform's level?
Correct.
Okay. So the transfer weight would just be whatever is in addition to what the vehicle would just be by itself?
Right.
Okay, so you cited him. Did he make any statements? Did he say anything to you?
There was some question over whether he was doing this for business. He claimed that he was pulling it for the registered owner, and it was his boat. So I did make some phone calls and found out that he actually was in business. He was going to sell the boat at auction to make a profit. It wasn't for his personal use.
Okay. Is there anything else about this encounter that you think the judge should know so they can make his decision?
I don't believe so.
Okay. I don't have any questions, Your Honor.
All right. Thank you, officer.
Yeah, thank you, sir.
Interesting about the transfer weight. I mean, that would make sense, you know.
Right.
Because there is some.
Yeah.
What percentage of the weight usually is the transfer weight? If the vehicle, if the trailer weighs 10,000 pounds, how much is usually transferred?
It could be, kind of depends on the
length of
the length and the setup. Could be as low as 500 pounds. Basically, the truck was not
big enough,
registered adequately.
Thanks, Judge.
Thank you.